Well, Court of Appeals of Tennessee is now in session.
Good morning, everyone, and welcome. We're going to conduct the proceeding this morning just as in the same manner we would in the courthouse. Mr. Johnson, I understand that you've requested 3 minutes for rebuttal time. That request is granted. Unless there are any preliminary matters we need to address, Mr. Hivner, if you will call the case.
John Doe versus Jane Roe.
Mr. Johnson.
Good morning, Your Honor. Michael Johnson with the law firm of K. Griffin. I am one of the lawyers for the appellant, Jane Roe, and that is a pseudonym. I know there's a little bit of confusion with the clerk, but that is a pseudonym, just like John Doe, the name of the plaintiff in this case. This is a defamation lawsuit. Plaintiff sued Ms. Roe, our client, for defamation and intentional infliction of emotional distress after she reported to the MTSU Title IX office that the plaintiff sexually assaulted her, Ms. Roe. Ms. Roe then filed a petition in this case to dismiss under the Tennessee Public Participation Act, which was passed in 2019. The trial court denied this motion, and our client took advantage of the direct appeal under the statute, which brings us here today. Now, we're arguing that the trial court erred in denying our client's motion to dismiss under the TPPA because the TPPA is triggered where either there is a matter of public concern, which is defined extremely broadly, or there was a report to a governmental body like MTSU.
Was the petition?
Sorry, go ahead. No, go ahead.
Was the petition to a governmental body argument made below? Yes,
Your Honor.
Did the court actually ever address that in its order?
It did not. It addressed it at oral argument. Well, I don't have the order pulled up, but my recollection, I know that it addressed it at oral argument because we inquired about that when Judge Brothers gave his ruling, if he was denying on that ground as well, and he said he was. I thought we included that in the order, but it's possible we did not. But he did deny it on the basis of both grounds.
Thank you.
I have a question also, please.
Yes.
I just want to make sure that I understand correctly. The only ground that you're actually appealing is the Title IX ground. Is that accurate? We
are appealing both the ruling and arguing that there's two things that trigger the statute here. One is that this is a matter of public concern.
No. In other words, you had other claims in your complaint, but as I recall reviewing your brief, the argument is with regard to the Title IX complaint. Is that correct?
So, no, Your Honor, I don't believe that's correct because I think that there was some argument in plaintiff's brief about this. Defendant, our client, moved to dismiss the entire legal action. That's how the statute, what the phrase the statute uses, which is any claim or defense that is a matter of public concern, any claim. It's a matter of public concern or otherwise is triggered under the TPPA. So we moved to dismiss all claims, including the Title IX piece. So there were claims about a social media post. There were claims about some statements to family and friends. We moved to dismiss all those claims.
All right. But you, Mr. Johnson, you had two separate motions to dismiss. And the only one that you're pursuing has to do with the Public Participation Act. Is that right?
That's correct. I'm sorry, Your Honor. Yes.
Yes. Okay.
We filed a motion to dismiss because the statute the filing of a TPPA petition under the statute does not obviate the need to actually respond to a complaint. So procedurally, we had to either file an answer or a motion to dismiss. So we filed a motion to dismiss to accompany the petition.
I guess my question, I wasn't specific enough, but you had claims of false light. You had intentional infliction of emotional distress claims and whatnot. I didn't understand from reviewing the brief that you were appealing the non-dismissal of those claims as well. My understanding from reviewing the brief that you were limiting the appeal to the Title IX complaint.
No, Your Honor, we're appealing all causes of action. So defamation, false light, IIED, because they're all tied to a matter of public concern. That's our primary argument. And second one, that with respect to the Title IX claim specifically, that's a report to a government body under the TPPA.
But you get here on this appeal pursuant to the PPA, and it only seems to allow us to consider the applicability of the PPA. So I don't know how that we reach those. I mean, how do we reach those other concerns? It doesn't seem like to me that the statute opens the floodgate up to every denial of Rule 12, every ground for denial of the motion to dismiss.
Correct, Your Honor. And so we are not moving on the motion to dismiss. Our appeal has nothing to do with Rule 12. Okay. Our appeal is solely with respect to the TPPA. And so what we're looking at is, you look at where the TPPA says first, if a legal action is filed in response to a party's exercise of, among other things, the right of free speech, the right to petition, then you can move to dismiss under the TPPA. So legal action is defined as a claim, a cause of action, petition, cross-claim, however denominated, for equitable relief, for legal or equitable relief. So it's any claim for legal or equitable relief. And if it's filed in response to a party's exercise of the right of free speech or the right of petition, then it triggers the TPPA. So our reading of the statute is this applies regardless of how you style your cause of action against the defendant. The TPPA is triggered if the legal action, as defined in the statute, a claim, cross-claim, however you want to, any type of claim, is filed in response to a party's exercise of the right of free speech, right to petition, the other things listed in the statute. And so our argument here is that this is a defamation case filed against our client because of her exercise of her right of free speech and or her right to petition. And the claims alleged are defamation, false light, and IIED, but those are all filed in response to the exercise of her right of free speech or right to petition as defined under the statute. And so the statute says if our client meets her burden to show that this is a matter, that this is a legal action filed in response to her right of free speech, right to petition, et cetera, that the burden shifts to the defendant to make a prima facie case on each element of their claim. The very broad definitions under the TPPA of free speech and right to petition that's where you get the matter of public concern issue. So exercise of right of free speech means a communication made in connection with a matter of public concern. And matter of public concern includes, but it is not limited to, includes an issue related to, is the way the statute phrases it, health or safety. There's no requirement that this be related to public health or safety overall, it's just health or safety, or among other things, any other matter deemed by a court to involve a matter of public concern. And of course, exercise of right of petition involves the petition of a government body. Now, based on the briefing, it's our understanding, and I think we addressed this briefly in our reply brief, that there appears to be no dispute that this involves a matter of public concern and that the Title IX complaint was made to MTSU, which is a government body. We've quoted the sections of the plaintiff's brief where that this appears to be undisputed. So the dispute is more with respect to plaintiff's reading of the statute, and I won't belabor that point because we've addressed that in our reply brief. But our position is that there seems to be no dispute that this is a matter of public concern as it's broadly defined in the statute, and that therefore every claim asserted in the complaint triggers the TPPA, that this is a legal action filed in response to our client's exercise of her right of free speech, i.e. a statement regarding a matter of public concern. That triggers the TPPA, which shifts the burden to the defendant to make a prima facie case on each element of his claims. Now, as we explained in our briefing, the defendant did not attempt to make a prima facie case on each element of his claims before the trial court. The only evidence he submitted was an affidavit. It says nothing about, most importantly, his damages. Actual damages, as this court is aware, is an essential element, constitutional essential element of defamation claims. So for that reason, the defamation and the false light claim both fail. There's no proof of actual damages, no reputational damage, no monetary damage, nothing like that. And so the false light claim specifically, we've got the publicity issue, no evidence before the trial court of publicity, that any statement at issue here was given publicity sufficient to trigger a false light claim. And the final claim, the third and final claim, IIED, same issue. There's no evidence of damage here, no evidence of severe emotional harm.
Let me ask you this: if you have the initial burden of showing that it's covered by the act, which is essentially where this case ended at this point. So, and the court determined that it was not covered by the act. So, would there not be a situation where, having not gotten past the first hurdle, was it necessary? The burden would only shift if the court found that the act applied. And if the act applied, then the burden would shift to the other side to prove its case or establish a prima facie case. It never came to that.
That's correct, Your Honor. The statute is a bit unclear procedurally on how that would work, if there's just one round of briefing or if the court bifurcates into separate hearings, the question of whether the statute applies and then whether the defendant or the plaintiff has made a prima facie case on each element. Our position on this is that the briefing closed, we went to a hearing, that the defendant and the plaintiff both submitted affidavits in support of their arguments and positions, and the defendant did not attempt to make a prima facie showing. Now, is it within the court's discretion to hold a bifurcated proceeding, one first deciding the applicability of the TPPA and then having an evidentiary hearing on, or essentially a mini trial on each element of the claim? Yes, I think that's within the court's discretion. The statute is not clear on the procedure for that.
Is there any help from any other jurisdiction like Texas or California about how they've handled this on a remand?
I do not recall finding a case where the court, but I'm not sure that I'm actually not sure that I specifically looked for this, a case finding, reversing on applicability and finding that the judgment should be rendered in favor of the defendant because there was no attempt to make a prima facie case.
Let me ask, well, okay, that's fine. Let me go to the matter of public concern. If we were to assume for a second that Mr. Doe here does not concede this is a matter of public concern, you cite Lewis against News Channel 5 for the proposition that really matters of public concern, context is really important here. So how would you say, speaking with a friend about a sexual abuse allegation, which may ultimately be untrue, is a public concern? I mean, how does that implicate the public at all?
Well, first of all, I want to address one point you made there about the may or may not be true. So at this stage of the analysis, whether something falls within the TPPA in terms of the definition of matter of public concern, truth or falsity doesn't come into the analysis. The question is just, is the statement a matter of public concern, or does it touch on, or as the statute says, is it related to a matter of public concern? And our position, based on a number of cases in other jurisdictions that have talked about crimes, sexual assaults, things like that, even private reports of sexual assaults, like there's a California case that we cite because that's unfortunate. That's one of the main jurisdictions that on the interpretation of anti-SLAPP statutes. But there's a California case that we cited in our brief that talks about how even a private report of, in that case, a sexual assault, but I believe it was a physical therapist, reports to her parents, the victim's reports to her parents fell within it was a matter of public concern because it involved a crime. It involved a rape. It involved an allegation of rape.
But that involved a minor, right? Was your client?
Some of the allegations in that case involved, yes, I think she was a minor at some points, and then she reached majority at some point.
Yeah, it strikes me as different because you want minors to report to parents so the parents can in turn go to the police. But when you got an adult reporting to a friend, I don't understand what the public concern is there. I mean, generally the public might have an interest in making sure that survivors of assault get comfort from friends, but that's not really a public concern, is it?
So based on the case law from other jurisdictions, we would submit that it is, because if you look at I think it's our footnote 4, we cited a litany of cases from other jurisdictions talking about everything from sexual assaults to down to animal cruelty. For instance, there's a case from out of the Texas Court of Appeals where they said that online posts in community forums about alleged criminal mistreatment of a dog were communications made in connection with an issue related to a matter of public concern. And so our position is that anytime someone's reporting a crime, a rape, and particularly in this context, in the context of college rape culture, based on the attention that it got under the past administration with the new rules put in place by Betsy DeVos and the Department of Education in the Title IX context, college rape culture has been hotly debated. And so, particularly in this context, a report of a rape that happened between college kids in this context, we think is particularly a matter of public concern. And again,
Right.
plaintiff.
Thank you, Mr. Johnson.
Thank you.
Is there any other questions from the panel?
No, thank you.
Right. So we'll hear from the appellee, Ms. Owens.
Thank you, Your Honors. I first want to state that we in no way conceded that the TPPA applied, and I'm not really sure where Mr. Johnson is getting that. I would like to point out the difference between a lot of the case law and the TPPA and what we have here. This is a Title IX matter, which occurs in a college facility or a high school, as the case may be, but this was a college. This is not a report made to a criminal body or to any other institution like that. This is not even really an administrative hearing because of the way that it's handled on college campuses. So whether or not MTSU is a governmental body under the TPPA, I think has yet to be proven. And we did address that in our brief, but only briefly. And it was not something that I recall being clearly decided in the lower court. I do have the feeling that Judge Brothers did not think it applied kind of overall, but primarily because this was an issue between two people. This was a private matter between two individuals, and it is not what the TPPA was intended to address. This is a matter of, if you look at it generally, broadly, it's a matter of public concern, but that is not how it was addressed by the complainant, Ms. Rowe. She addressed it very privately. It was very individual for her. And I look at it, this Title IX is often compared and contrasted with employment law. And so under Title VII. And so when you look at employment law, and if you look at labor law with the National Labor Relations Act, which I'm sure you're all familiar more than I am, when you look at that, you have to do something to help everybody else in order to be considered doing something that could be union activity. In other words, if you're trying to form a union, you can't just be talking about yourself and trying to help yourself. It has to be for the good of others. And I think that's a very good analogy for what the TPPA has to be. It has to be for the general welfare. And yeah, talking about sexual assault in a general sense is definitely for a part of the general welfare, but that's not what Ms. Rowe was doing. And additionally, there was not the intent, and it didn't happen, that Mr. Rowe was trying to prevent her from filing her claim. This was not done in retaliation because he waited until after MTSU had made its decision. They heard the case about sexual assault, found him not responsible, and then he determined that because of the damages he had suffered, he would file this defamation claim because he did suffer a lot of damage. And boys, when they go through this, and they are boys, their frontal lobes are still not developed at 22, and they go through a lot of emotional damage. And for his career, what he wanted to do was be a professional airline pilot. He had to actually switch careers because he would never be able to get hired on with a professional company.
So counsel, is what you're arguing that we should adopt sort of the California standard that there has to be, for it to be a matter of public concern, there has to be an ongoing controversy? Is that what you're proposing?
And I'll be honest with you, I'm not quite clear. I've read several of the different statutes in different states, and I don't remember California specifically, but I don't know about an ongoing concern. I think it has to be more than a private concern. It has to be something that affects more than just me and the other person. It has to be something that affects the country at large, a group of people at large, something in general.
Well, what about
Not-
what about the university at large? What about the fact that this was a complaint related to alleged sexual assault on the university campus, a state-owned institution, and admittedly, this statute is a rather odd statute because it appears we're operating from definitions, not definitions that are arising out of purpose and whatnot. So I acknowledge it's difficult, but there's so little on this. But the statute clearly says a matter of public concern includes an issue related to health or safety. And so how can we interpret this to say that this does not involve health or safety on a state-owned university campus?
Well, I think that it does apply to health and safety if it is brought about in a general sense. Like where
does that come from, though? Where do you get that from? Where does it say in the definitions or anywhere in the statute that it only applies in a general sense rather than a specific sense? I'm not seeing that.
Let me see if what I have in my brief makes sense. The purpose of the chapter, this is from the TPPA, is to encourage and safeguard the constitutional rights of persons to petition and speak freely, to associate freely, and participate in government to the fullest extent permitted by law, and at the same time protect the rights of persons to file meritorious lawsuits for demonstrable injury. This is consistent and necessary to implement the rights of the Constitution. And that's Tennessee Article 1, Section 19 and 23. The facts and veracity of each individual case is very important when applying the TPPA. As other jurisdictions have found, there is no one size fits all when analyzing the relevant factors. That's from Shoreline Towers Condo Association. And that is let me see where that is from. Shoreline is from Illinois. So that's an Illinois case. The purpose of the act is to strike a balance between the rights of persons to file lawsuits for real injury and the constitutional rights of persons to petition, speak freely, and otherwise participate in government. The anti-SLAPP legislation is not intended to protect those who actually commit torts, but to protect those who are in danger of being sued solely because of their valid attempts to petition the government. So that's where I'm getting it. So if you are and to me, when I read that, I think if a group of people is trying to change the law on campus or the rules on campus, the policies, and they are sued for that, or they are charged for that in some reason, that would be something that is affecting a group. But when you have one person, one boy, one girl, or whatever the case may be, and you are talking about the facts that happen just to them, I don't think that affects the general welfare of anyone. It doesn't affect the policies of the campus.
Well, it certainly couldn't. In other words, in determining about on the extent of sexual assault on the campus, or whether or not the person who committed the sexual assault has committed sexual assault against others. We don't know all the facts, but we are talking about a Title IX complaint to a state institution. So it's
right.
That's what I'm trying to.
I don't see how we get from an individual making a complaint to it affecting the entire campus. There are Title IX rules and policies, and that is certain, but one person making a complaint, what you're saying, if that is the case, is that somebody can lie about you and make up something, and that you have no right of recourse for that. There's no recourse for what they do.
That's not exactly correct, though, because the statute just shifts the burden. In other words, if you can prove your prima facie case, you still have a right to go forward. So, I mean,
Let me ask you,
you do have a
go ahead.
protection within the statute.
I'm
Ms.
sorry.
Owens, isn't it the filing of the Title IX complaint that triggered the defamation action? Because in this case, I don't know, since you didn't do all the discovery, but I assume that your client may have known that she spoke to one or two people about what she alleged happened. No defamation action was filed. Of course, there was no publication, really. You're telling one or two people, friends, is not a publication of a defamation. But in this case, no action was filed until after the Title IX complaint was filed. And then your client perceived that he was successful against this Title IX complaint. So what triggered the defamation suit is her exercising her right to file the Title IX complaint. Isn't that true?
Well, no, I would say what triggered the filing of the defamation complaint is this woman lying about him and making false statements about him to a governmental institution. So, maybe it's 6 of one and half dozen of the other, but it's not just the fact that she filed it, it's that she filed something that was incorrect, that was false, that was libelous. That's what the problem was. Filing something that was true, and generally, I don't get those cases, and generally, those are filed with the police. So I think you have a little bit of an issue here when you're talking about Title IX, because you aren't dealing with a criminal, institution, with a criminal jurisdiction. You're dealing with a school, and every school handles these differently. So there's no generality in the way that, even within Tennessee, you may have a law in Tennessee, but every school in Tennessee handles the Title IX aspect differently. They're allowed to. So you have no real consistency in the way that it's applied. So I understand what you're saying, that the Title IX, and I can say in one way, yes, the Title IX did trigger it, but I don't believe that if the Title IX if he had been charged with something he did, we would not have filed a defamation claim, because that would have been ridiculous. I mean, we filed it because it damaged him and it was a lie. And we feel like we're allowed to do that.
And how do you lose your cause of action here? In other words, if the act applies, then the burden just shifts to you to show a prima facie case. That's what the statute says. If you can show a prima facie case, you're entitled to go forward.
Well, I didn't read it that way, but I would love it if that were true, because what happens in most states is that if it's just dismissed, no questions asked.
Well, let me read this to you. 20-17-105 parens B parens says this is after the initial petitioning party has the burden of making a prima facie case. If the petitioning party meets this burden, the court shall dismiss the legal action unless the responding party establishes a prima facie case for each essential element of the claim in the legal action.
And I agree with you. That's what it says. That's not how it's handled in a lot of other states, because I work with a group of attorneys who do Title IX. And so I know the problems that they have with this. And when TPPA comes up, if it applies, then it's just dismissed. And I just don't think it applies to this. I don't think this was what it was meant to address. I don't think an individual matter between two people is what this was meant to address in any way whatsoever. I mean, I think that it's meant to allow people to file lawsuits and protect their rights to do so, but not in a private matter between two people that's not a matter of public concern. And I don't believe that this is a matter of public concern, even though it is a Title IX matter, because Title IX is not going away. There's still the policy on campus. But if someone lies about you, you should have the right, without having to swap the burden, you should have the right to file a lawsuit if there is a lie. And then if you lose, you lose. But right now, the TPPA would say you can't even file it, unless you go to more links and swap the burden, which, I mean, I think this whole thing is just a matter of preventing my client from pursuing his rights. He was falsely accused. He's the one who's out damages, reputational, class, money, otherwise. And the TPPA has held this up for about a year now because of the automatic right of appeal and the automatic stay on discovery. So we're at a standstill because of this act, and it's just further affecting him in a negative way.
Is there any other questions from the panel? All right, thank you, Ms. Owens. Mr. Johnson, we'll
I
hear
have
from you.
58 seconds left, don't I?
Oh, yeah, you do. Please proceed.
Let me see if there's anything else I need to say.
I apologize for cutting you off.
I won't take that as a bad sign. I wanted to say a couple things just about the amicus brief. Most of the cases in the amicus brief that were filed before Title IX came into effect. Title IX did not go into effect until 2011. And I'm not sure how familiar you all are with this, because either you know it because you've addressed it or you have no idea what it is. And if you have no idea, that's okay. It's actually good. It means you haven't been charged. But in 2011 is when it applied. All of the cases that, I think almost every one of them in this amicus brief deal with things other than Title IX. So you can't look at an amicus brief that says that, this applies to Title IX when all of the case law is written before Title IX. So that's all. Now my time's up.
Ms. Owens, I allowed you a few more seconds because of my
Thank you.
interruption there. So thank you, Ms. Owens. Mr. Johnson, we'll hear from you on rebuttal.
Thank you, Your Honor. Very briefly, I just wanted to touch on a couple things. First, matter of public concern. What we were pointing to in our reply brief is page 16 of plaintiff's brief, which says sexual assault in general is a matter of public concern, and sexual assault on college campuses has become one of the central topics of debate as of late. We wholeheartedly agree with that. The plaintiff seems to agree that this is a matter of public concern. The debate seems to be whether there can be some sort of additional condition read into the statute about the general public good or something along these lines. But what the statute says is if it includes that matter of public concern, freedom of free speech, right of free speech includes, I'm misstating that. Matter of public concern includes health and safety, any other matter related to public concern, and it's not limited to that statute. It's not related to a matter that affects the public. It's related to a matter of public concern. So the fact that this is a Title IX complaint, the fact that this is a private complaint, all of those types of issues is background facts.
But you could say the same thing about workplace misconduct too, couldn't you? That's a matter of public concern?
Yes, and courts have held that.
Well, but
cited those in our brief.
Not in every case. California has said that your garden variety, whatever that is, workplace misconduct is not a matter of public concern. It has to involve a public figure or something that affects others besides, the two involved in the workplace. So, it seems like to me, if you say every case of sexual harassment is automatically public concern, then that swallows up the entire, it's always going to be a TPPA case. And I'm just not sure that was intended by the statute. Yep. Go ahead,
and I think the problem is as drafted, I think it is that broad, that almost anything could be a matter of public concern. And it's a matter for the legislature, if they want to narrow this. Courts across the country, I agree. They've come out to different ways on issues like that. Like, is sexual harassment always a matter of public concern, or does it require other elements? Cases go both ways, and I think both parties have cited cases to that effect. But in our case, the statute's pretty broad, and that's what we've got. And so we're submitting that this in particular, that these facts in particular this is a matter of public concern, especially when you're dealing with a Title IX complaint, an alleged rape on a college campus. All of those things make this a matter of public concern. Would every rape be a matter of public concern? I think that's a question for a different day. But in this particular case, we do think that this is a matter of public concern. And again, on page 16 of the brief, plaintiff seems to agree. Now, on the government entity thing, issue, same thing, page 22 of plaintiff's brief.
Mr. Johnson, your time is up. and
Oh, I'm
I
sorry.
think Out of fairness, I need to
Yep.
stop you on time since I stopped Ms. Owens early. So let's be fair on that. The case is submitted. Thank you both for your arguments. Very interesting case. Mr. Hibner, if you will recess us until I think 2 p.m.
The Honorable Court is now in recess until 2 p.m.
Again, counsel, thank you. You may leave the meeting.
Thank you, Your Honors.